after than he was when he was here. Additionally, speaking, and I'd like to publicly thank you, for some of the quotes you gave to the family, and I guess, quote, I don't know about quote, trying to keep the family out of trouble, as Soli's usual MO, would have dictated otherwise. Anyway, I'm one of the petitioners here. Nationality, Hawaiian subject, racial and by U.S. definitions, a Native Hawaiian, and by conduct, cultural identity, and for this contested case hearing, a Native Hawaiian cultural practitioner.
I'm sorry, I'm having a hard time hearing.
All petitioners here, including those who claim to be Hawaiian.
Clarence, can you stop 1 second? The folks that are outside the door, could we have you quiet down a little bit? The court reporter is having a hard time listening to the testimony. No, Clarence, stay.
Go ahead. I just couldn't hear what you needed, guys. Hawaiian subject, racial by U.S. definition, Native Hawaiian, and by conduct.
All petitioners here, including those who claim to be Hawaiian cultural practitioners, were held to be admitted as parties having qualified for standing by Minute Order Number 6, order regarding standing on May 27, 2011. Furthermore, standing plus an additional standing qualification in regards to constitutionally protected Native Hawaiian cultural practice. The HO failed to provide prior notice of his intentions and failed to include such standards for qualification in Minute Order Number 1, the Notice of Standing and Pre-Hearing Conference dated April 10, 2011, or anywhere else. Such error cannot be tolerated in retrospect. There is no discussion anywhere in the record of HO's finding of facts, conclusions of law, or decision that outlines the specific standards that he would use to evaluate a cultural practitioner's qualifications under the umbrella of constitutionally protected, constitutionally guaranteed protections. The HO further erred by modifying the standards of proof for civil cases by using Hanafi's criminal standards for qualification. To be held to standards that don't exist or noticed must in the least be a violation of petitioners' due process. Additionally, petitioners Mauna Kea Nanaho and Clarence Kukaukai Ching were petitioners in the contested case hearing on the Conservation District use application for the construction and operation of 6 1.8-meter outrigger telescopes. In that contested case hearing, whether or not these petitioners were qualified as Native Hawaiian cultural practitioners was at issue. The HO in that CCH hearing found and concluded that these petitioners were qualified for standing with constitutionally guaranteed protections as Native Hawaiian cultural practitioners. This board, based on the qualification of said petitioners in that CCH and appeal, is res judicata, and the HO is stopped to re-challenge said petitioners for standing in this CCH. It is especially absurd when the finding and conclusion here is 180 degrees out of kilter, a denial of such protection. The law does not favor such inconsistency and uncertainty, and the HO erred. Mary Fukui in Manahiki Kumu, Look to the Source, Volume 1, page 94, says that in Hawaii's early days, one's name was one of one's most precious possessions, and one's Inoa name was both owned property